This is the Observations Podcast for Sunday, the 9th of April, 2023. Welcome back to the podcast. As you can see, it's just me this week. Michael is unavailable this week. He's also going to be unavailable next week. So we're about to find out whether I can pull off a show all on my own. We'll see. Got a couple of things to talk about today. I am going to cover the indictment of Donald Trump, and we're going to actually look at it in a fair amount of detail. There's also a weird tweet response that I got this week that I want to talk about, and anything else that comes to my mind, assuming, of course, I can carry off a show all by myself. Now, I used to do this for a living, I used to broadcast business and financial news for 4 hours a day in Los Angeles, so I should remember how to do this. We will see. That, by the way, reminds me, speaking of, I used to work at a station in Los Angeles called Money Radio. It was a 24-hour business and financial news station. And I started off there as a producer and then got promoted into being an anchor. So I was the anchor in midday from 9 to 1. And it started off as a 24-hour business and financial news station. And then about 2 years after I was doing my little anchorman duties there, they sold half of the time from 9 p.m. or from 5 p.m. to 5 a.m. They sold to ethnic Chinese programming, so it was all in Chinese. I kind of saw the handwriting on the wall. Also, they refused to give me a raise, so basically I quit, found a new job, and ended up doubling my salary overnight, but I left. And this was several years ago, right? This was back in 1996-ish. 96, 97, somewhere in there. Anyway, night before last, it was last night. No, it was night before last. It was Friday night. I was playing on my Xbox. I was playing No Man's Sky. And I went to this planet where a ship was advertised that you could pick it up. And somebody came in over Xbox with a chat that said, "Are you the Dale Franks that used to work at Money Radio?" And I replied back, "Well, it's, been a few years, but yeah, I am." And it turns out that this was a guy who worked as a board op and production guy for the radio station at the same time I did. And in fact, when I left, he was the guy that replaced me as the midday anchor at Money Radio. And so it's weird. Now he lives all the way across the country. He now lives on the East Coast, so he completely left California. Good idea. And after what is it? 20, almost 30 years, 96, let's see, 2006, 16, 23, 27 years later, this guy just finds me on Xbox. It was the weirdest thing. And then yesterday, I went on to Reddit and was looking at a Reddit that is related to that particular game. And he had posted there saying he met somebody, it was a friend of his from years back that we just met while looking for this particular ship. And of course, I replied, "If you're who I think you are, it was me that you met." And certainly enough, it was. So it is a small, weird world. So that's just a weird thing that happened to me this week that I thought I would start off with to ease into our topics for tonight. So first thing I want to talk about is this weird tweet that I got. I don't know if you remember, me and Michael were talking last week or a week before last about how one of my tweets got picked up and quoted by Fox News, and then it got repeated by Instapundit, and it got a lot of traction, and I got a lot of responses. And like anything with Twitter, of course, that happens for 2-3 days, and then it just fades away. It goes into nothing because everything on Twitter is current. And so things that are 3 days ago might have as well have been an eternity ago in most cases. However, that's not always true. So after, a week of nobody mentioning this, I got this tweet responding to it last night. And I wanted to talk about it because it really gets to the sort of self-image that the cultural Marxists have of themselves, which is actually kind of a reversal of the way things really are. And by the way, I always hate it that people think that I am defending the GOP when I go against progressives. Just because the GOP is anti-progressive in a way doesn't mean that I agree with the GOP on everything. I am not a Republican. I have not been a registered Republican for a long time. So I am an independent in California, where I live and where I vote. So I'm not a Republican. However, let's leave that aside. Let's just look at the tweet itself. Dale Franks, how, in jeopardizing our civil, voting, and human rights, is the GOP limiting government power? Everything they do is harmful overreach. Okay, let's discuss that. I'm looking at your title, which is Unite Against Fascism. So I am going to just suppose that you are some sort of cultural Marxist and that you are obviously a progressive. And I'm sure you're a perfectly nice person. But in this case, you're just wrong because you have a false self-image of what the GOP is doing. Although I will give you the benefit of the doubt, the GOP does some hinky things. The GOP is not the pro-liberty party they make themselves out to be. But let's leave that aside for now. Let's just talk about the Democrats. Okay, so now that I think I have a pretty good handle about who you are and what you believe politically, let's talk about it. So, how are the Republicans jeopardizing our civil rights? Well, if you want to talk about civil rights, let's talk about criminalizing, or at least ending the protections of what you would call hate speech as an exception to the Second Amendment. Because I'm fairly sure that if you toe the line on the normal progressive policies, you believe that there is some sort of hate speech amendment to, or hate speech exception to the First Amendment. Well, I have bad news for you. There's not. People can say hateful things. People can say wrongful things. Say what you want about the Republicans. They're not trying to restrict the First Amendment or take entire categories of speech and say this is not First Amendment protected speech. The left, on the other hand, or the progressives to be more precise, because the left, at least the traditional left in this country, were always very strong civil libertarians. We're always very strong supporters of free speech. The progressives are not. And they want all of these different things. If you say something, it may be racist, it may, whatever it may be, they want it to be unprotected by the First Amendment. So presumably you could be sued for it, and presumably you could be arrested for it. It could be criminalized because it is no longer protected speech. It's not the GOP arguing for that. It's the progressives, and largely progressives in the Democratic Party. They're the ones that want to carve out exceptions for the First Amendment. And let's not even get started on the Second Amendment. They don't even believe that you should be able to own guns at all, despite the clear text of the Second Amendment and despite what the Supreme Court held in Heller and Bruin, which recognized the Second Amendment as an explicit individual right, whether you like it or not. You would rather have that removed from the Constitution and prevent people from, in many cases, even defending themselves. The fellow that we are going to talk about, Eric Bragg in New York, the DA who indicted Trump this week, well, let's see. He has 2 cases where he has charged people with murder because when they were attacked by robbers who were armed and a struggle ensued, they ended up killing those robbers. And now they've been charged with murder. Okay, so I guess now we can't even defend ourselves. I guess now what we have to do is just let criminals run roughshod over us. And if we defend ourselves, and God forbid, if we defend ourselves with a weapon and the person who attacked us dies, all of a sudden we're guilty of murder? No, 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 no. We have an absolute right to protect ourselves. So when you come at me from the left and you talk about your big concern for civil rights, go screw. because you don't. Let's talk about voting rights. One of the key elements of a reliable and trustworthy electoral system is knowing who is voting, whether they are authorized to vote, and whether they are only voting once. It's called election integrity or voter integrity. And every time any state comes up with a voter integrity law, a law that is designed to ensure the trust and reliability of our elections, like they did in Georgia a couple of years ago, it's immediately called, well, it's Jim Crow, it's racism. Why is it racism to require someone to have ID to vote? Are you assuming that poor and minority people are incapable of obtaining IDs, that they're intellectually stunted in some way that prevents them from getting a free identification card from the state? Because that seems to me like a more racist assumption than just saying you have to identify yourself to vote. It twists the whole idea of electoral integrity on its head. Oh, and by the way, if you constantly oppose every single measure for electoral integrity, don't tell me how concerned you are about the right to vote, because the real result of what you're doing is to dilute the actual votes of citizens. So, New York City, another prime example here. New York City seems to be a prime example of a lot of things where they are now allowing illegal aliens to vote in New York City elections. So then what's the point of citizenship? What say do citizens have in the government of which we are a citizen and of which we presumably to which we presumably have allegiance? How is that different than somebody who breaks the law, comes here illegally, and now gets to have a say in how this country is governed? A country for whom they have so little respect that they didn't even obey the law in coming here. So again, when you tell me as a progressive how concerned you are about voting rights, go screw. And this is indicative of what the left does. They twist everything on its head to make themselves come out as the people who care about human rights and civil rights and voting rights. Yet the policies they espouse are policies that restrict human rights and restrict voting rights. Certainly, it does away with the idea of citizenship being worth anything. And of course, why would citizenship be worth anything? Why would you want to be a citizen of a country that you consider irretrievably racist? I guess that's a question that you would have to answer as a progressive. But don't come at me with all of these restrictions that you want to put on actual civil rights and then tell me that you are somehow the big defender of civil rights when you're willing to, ban people, censor people, sue them, perhaps even imprison them for saying things that you don't like. And it's the First Amendment thing that really irks me. Popular speech doesn't need to be protected. A First Amendment that says you have the right to say anything you want that we like is not freedom. It's not a right. It's basically the imposition of an ideological litmus test on what you can say, and that is completely antithetical to the founding principles of the United States and to general principles of liberty and freedom anyway. So I got a little irked at that tweet, and I would have responded on Twitter with my little 280 character response, but I had more to say than I could shove into 280 characters, so I thought I would shove it in here. All right, let's talk about the indictment of Donald Trump that was filed in New York. By the way, this is the first hot day. I'm going to get out of camera range. In fact, there's a couple of things I can do. I don't need these headphones. I'm not talking to anybody. I guess I needed them to hear the music, but I don't need them now. Let me come back here and grab a little rag because I can just feel myself starting to sweat here under these lights, which I shouldn't. But like I said, very, very warm day today, and I haven't turned on the air conditioner or a fan or anything, so I'm feeling it here in the room. I crave your indulgence for my excess sweatiness today. Okay, let's talk about the indictment, and we're going to get into it. We're going to get into it in a little detail. Some caveats. I am not a lawyer, and I'm certainly not your lawyer. I'm not a defense lawyer. I'm not a criminal lawyer. I'm not any kind of lawyer. Michael is a lawyer, although he is a civil lawyer. He's not a criminal lawyer. I really wish he could be here tonight for us to go through this. However, I will try to sub in because I did spend 10 years as a law enforcement officer. I was a military policeman for 10 years back in the 80s and early 90s, and I have some familiarity with how to write up charges that get passed off to, in the military's case, it's the JAG, the Judge Advocate General. The military doesn't have a grand jury in the sense that civilians do. So this indictment came from a grand jury. Grand juries generally meet for, a day a week for 6 months or a year. And the prosecutor presents them with his side of the story to try to convince them to indict a criminal defendant. And as the saying goes, a good prosecutor can convince a grand jury to indict a ham sandwich, which I think is largely true. The military justice system doesn't work that way. In general, the way it works, certainly from the military police side, is we investigate a crime. We try to find out what happened. We write our reports on that crime, and then we pass our report with the charges that we believe should be filed against a particular defendant that specify all of the elements of the crime, so that, and those elements in the military are specified in the Manual for Courts Martial, which lists every article of the Uniform Code of Military Justice, including certainly all of the penal articles, and then specifies what elements have to exist for that crime to be true. We're going to look at those elements for the crimes that Donald Trump is charged with here in a minute. Now, while the Uniform Code of Justice is a unique set of laws in the United States, and so the military exists under the UCMJ, they don't exist under other civil laws, it's their own code. Outside of that, military police generally follow all of the procedures that are specified for federal law enforcement officers, and usually the FBI is the one that writes up all of these procedures. And everybody who works in federal law enforcement basically has to live or die by these procedures. So it doesn't matter whether you're in the military or the FBI or U.S. Marshal Service, those are the rules that get promulgated to everybody. So having said that, while I'm not a lawyer, I do have a fair amount of familiarity, both professionally and in the years since in study, which I think allows me to have a very well-informed layman's, non-lawyers look at how charges are brought and how they're assessed. And with some experience in seeing how this works in the real world, I think I can help navigate us through here. Obviously, there's going to be things I miss because I'm not a lawyer. There may be things I misstate. Again, not a lawyer. So just keep that in mind. You might want to take what I say with a grain of salt, but also keep in mind that I'm not a complete newbie at this. I used to try to write up things to get people convicted of crimes, and so I'm at least familiar enough with how that has to be done. So with that in mind, let's take a look at the indictment of Donald Trump that came out this week. So this is from the Manhattan DA's document collection. As you can see, it's manhattanda.org. So I'm actually getting the original right from the Manhattan DA. Here are the charges. Let's take a look at these charges real quickly because I want to dispense with the charges themselves, and I want to move on to the statement of facts for this, because the charges, they're missing a couple of things, but let's understand how these charges work. Now, there are 38 counts here. So if we were to scroll down to the bottom, it's Alvin Bragg. I think I called him Alex Bragg. 23rd, 33rd, 34th count. So there's all these counts, 34 counts, which sounds like, oh my goodness, 34 counts. He must have done all kinds of horrible things. Well, hold on to your horses there. I saw a couple of commentators saying, these 34 counts, that's outrageous. Why, I've never seen a prosecutor charge 34 counts. Then you must not have had anything to do with criminal law for the last 30 years, because this is very common. Prosecutors overcharge like this all the time. Every single crime that could possibly be charged gets charged. We don't actually have to look at all 34 of these charges. Actually, we only have to look at the first 4. And I can explain what each one of these charges is in the first 4 charges. So, and I'm going to read this because there is going to be a audio version of this podcast. So while you're looking at it in the video version, you can read it, I assume, but I am not going to assume that for the audio people. So you're going to have to bear with me while I read through this. The grand jury of the County of New York, by this indictment, accuses the defendant of the crime of falsifying business records in the first degree in violation of Penal Law 175.10, committed as follows. So he's being charged with 175.10. Let's take a little detour and look at 175.10. Now, a few minutes ago, I was talking about the elements of a crime, right? And you know what? Let's plus in this and move right here to 175.10. And so this is, a person is guilty of falsifying records in the first degree when he commits the crime of falsifying business records in the second degree. So with intent to defraud, that's second degree. And when his intent to defraud includes an intent to commit another crime or to aid or concede in the commission thereof. All right, so that is the crime. And I think I may have grabbed the wrong thing. I thought I was grabbing 175.10 elements. This is not the page that I was used to. So let's go back to falsifying business records in the second degree. So falsifying business records in the first degree, the element is the intent. It includes an intent to commit another crime. It's 175.05, falsifying in the second degree, that has the elements. Sorry about that. Got a little confusing. A person is guilty of falsifying records in the second degree when, with the intent to defraud, so let's keep that in mind. Who gets defrauded here? We'll discuss that in a bit. If they make or causes a false entry in the business records of an enterprise, they alter, erase, obliterate, delete, removes, or destroy a true entry, or if they omit to make a true entry, or if they prevent the making of a true entry or causes the omission thereof. So any one of these 4 acts satisfies the elements of, if you, of course, do it with intent to defraud, the 4 elements of falsifying business records in the second degree. 175.10 in the first degree adds the additional element of an intent to commit another crime or to aid or conceal the commission thereof. So falsifying business records in the second degree, Class A misdemeanor, but if you do it with the intent to commit a crime or to aid or conceal the commission of a crime, then that is a Class E felony. So that's the crime he's being charged with. That's how we get to a felony here. However, that is a big bar, this intent to commit another crime. We'll have to take a careful look at that. All right, so that's what he's being charged with. Oops, went to the wrong tab. That's what he's being charged with. Let's go back to the indictment and take a look at these counts again. And again, we don't have to look at the first 4 because those are the 4 crimes that are charged from basically a single act. So let me show you how that works. So the defendant, with intent to defraud and intent to commit another crime and aid and conceal the commission thereof. Okay. He had the intent to commit another crime. What other crime? Can you specify it? Do you know what that crime was? I mean, you're charging me with it. How can I defend myself against this charge where you say I was trying to commit another crime if you won't list the crime in the indictment? By the way, not a fatal flaw. What it does indicate to me is that Alvin Bragg's office doesn't yet have a perfect theory of the case. Now, they can't let this indictment stand like this forever. because ultimately you're going to have to tell the defendant exactly what crime he was intending to commit or to conceal, so that they can prepare a defense for it. You don't have a choice, but you don't have to do it as part of the indictment. Again, I've seen some analysts say, well, look, that's fatal. They don't even mention the crime. No, they don't. A lot of times they don't, because they don't have a perfect theory that they're willing or ready to bring to a jury yet. They're probably arguing, and we'll talk about what they might be arguing over here in a little bit. But they're probably arguing about what exact crime they want to charge as the crime that they intended to commit. So they're going to leave it blank here. It's going to be a little loosey-goosey now. They're going to fill some of this out in the statement of facts, but not a lot of it. So this is going to require some discovery motions back and forth. And by the way, it's required in a criminal case anyway. You're going to have to come up with a theory before trial. You're going to have to present the defense with it so that they have the ability to defend against it. So right now, it's some crime that he was going to commit. We promise, but we're not going to tell you what it is. Again, not a fatal flaw, but it is an indication that they don't want to for whatever reason, they don't want to release what crime that might have been. I don't work in the DA's office there, so I can't tell you exactly what they're thinking, but we'll take a look at some possibilities in a little bit. All right, so here is the crime. He made and caused a false entry to be made in the business records of an enterprise, to wit, an invoice from Michael Cohen. So they put this invoice in the record, dated February 14, 2017, and they marked it as a record of the Donald J. Trump organization. Okay, so that's just the invoice. Now, when you get this invoice, obviously you've got to put it on your books, thus bringing us to the second two counts. Most businesses, I think probably all businesses really in the United States and pretty much everywhere else, use double entry bookkeeping, which means that for every credit entry that you place in your account books, you have to put in a debit entry in the account books. So I've now entered the fact that I received an invoice. So according to Alvin Bragg's office, that's my first crime. The second crime on the same date is an entry in the detailed general ledger for the Donald J. Trump Revocable Trust, bearing voucher number 842457. Okay, that's a general ledger entry. So there's your credit entry. And by the way, here is probably your debit entry, 842460. Or it may be the other round. This may be the credit entry. This may be the debit entry. But each entry, my debit entry and my credit entry, separate crime. Same invoice. Technically the same. It's the same act. I got an invoice. I added it to my books. I wrote a yay or nay, debit or credit entry in my books. And then the fourth count, they recorded a Donald J. Trump Revocable Trust Account check and check stub bearing check number 00138. Okay. So I've got the invoice, count 1. I've got 2 entries in my general ledger, counts 2 and 3. And then I've got the check stub from the Donald J. Trump Revocable Trust Account. And so that's my fourth crime. And so every other crime here is basically a repeat of that. It's basically 4 charges for the same ostensibly criminal act, if it is indeed a criminal act. So each act actually results in 4 criminal charges. Prosecutors do this all the time because now he's got 34 charges, only got to get a conviction on 1. How you would get a conviction on 1 without getting a conviction on all the others, I don't know in this case, but there we go. That's the actual indictment. Those are the nature of the charges. All 34 charges basically are based on these same 4 charges: invoice, 2 ledger entries, and check. Now here's an interesting legal question. I don't know the answer. I suspect we're going to have to find out. Just because the Trump organization is maintaining Donald J. Trump's records. Remember, Donald J. Trump is president at this time, so he cannot participate in the business. Everything that he has now goes into a trust that is managed by the Trump organization. So if we are writing checks out of the Donald J. Trump Revocable Trust, Donald J. Trump's personal money, not money from the Trump organization. This is Donald Trump's money. It's his trust, his checks. Well, that's really interesting. I'm sorry, I was on the wrong count. It's this check. Just because the Trump organization maintains those records for the trust account, does that make them a business record for the state of New York? Alvin Bragg certainly thinks so. But usually when we talk about a business record of, and again, this is where I'm not a lawyer, so this is where it's a little hazy for me. Now I'm in the I'm asking questions part of the broadcast. If this is Donald Trump's personal money and the Trump organization is just managing it, is it really a business record of the Trump organization, or are they just providing the accountancy services for Donald Trump? And Donald Trump and his revocable Trump, because by the way, that's where the entries are being made, the general ledger for his revocable trust containing his money, his assets. Is this an asset of the Trump organization? They're maintaining it, but do they own it? Is it their business record? I don't know the answer to that question, but and the answer to that question might be, oh yeah, they do. So there's no problem with it. Could be, but I don't know that that's true. And I think that is an interesting question. And I know I have read analysis from at least one former prosecutor that says, yeah, that's questionable as to whether just maintaining these records for the revocable trust makes them a business record for the purposes of this New York state law. Again, even if I was a lawyer, I wouldn't be practicing in New York. I've never lived there, and I've only visited there once. So I don't know, but I think that's an interesting thing to at least consider. All right, so here we have the indictment. I don't think there's any more reason to read it. There's no more facts that we can glean from the indictment itself. So let's take a look at the statement of facts that Alvin Bragg's office released. Now, this, by the way, used to be on their website. It's not anymore, and I don't know why. I can't find the URL. The URL where it was has been deleted, but fortunately, the Washington Post grabbed a copy of it. And so here we go. The defendant, Donald J. Trump, allegedly or repeatedly and fraudulently falsified New York business records to conceal potential criminal conduct that hid damaging information from the voting public. Okay, assertion. Let's see how you back that up. From August 2015 to December 2017, the defendant orchestrated a scheme with others to influence the 2016 presidential election by identifying and purchasing negative information about him to suppress its publication and benefit the defendant's electoral prospects. That might not even be a crime. If you go back and look at Citizens United, it might be an improper campaign finance violation if you are personally directing it with others, perhaps. And who are these others? We'll take a look at that. There's one person who it might apply to, and there's one person who it might not apply to. And in fact, it might not apply to either of them if Donald Trump wasn't personally directing it. Even if he had discussions with them about it, it might not count as him directing anything. So you know what? This might not even be a crime. But in order to execute the unlawful scheme, which, by the way, may or may not be unlawful, the two people that they talk about here, Lawyer A, which is Michael Cohen, And the company from the company that owns the National Enquirer, we'll get to it a little bit later. You know what? Citizens United says they can make independent campaign expenditures all they want for a candidate. As long as it's not at the candidate's direction, they can make pretty much any expenditures that they want privately. So that may not be a crime at all. So this unlawful scheme, that's very prosecutorese, but it also may not be true. You're going to have to prove that there was, in fact, any unlawful scheme at all. So the participants violated election laws and made or created false entries in the business records of various entities in New York. Well, business records? Maybe. Maybe not. I'm a little hazy on that because this is coming out of the Trump Irrevocable Trust, and it's coming out of the Trump Irrevocable Trust accounts. They're maintained by the Trump organization, as I said. Does that mean that they're part of the Trump organization in terms of its operations as a business entity? The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. Okay, that is technically true. It was mischaracterized, although the end result of this mischaracterization, as we will see, was to actually pay more in taxes than were actually owed, or that would have been owed if you would have wrote down the actual entries, which is whore money payoff. If you'd written that down as a business expense, money to pay whores to keep their mouth shut, then that would be a true record. It would be mischaracterized, and they would have owed less taxes had they done that. So yeah, it did mischaracterize them for tax purposes. But again, how is that defrauding? Because we still haven't figured out who is being defrauded here. This indicates that it is the people of the state of New York that are being defrauded because we've mischaracterized it for tax purposes. But in point of fact, the people of the state of New York benefited from this. They were not defrauded. They got more money than they should have gotten, as we shall see in a few minutes. So one component of this scheme was that at the defendant's request, a lawyer who then worked for the Trump organization as a special counsel to the defendant, lawyer A, that's Michael Cohen, covertly paid $130,000 to an adult film actress shortly before the election to prevent her from publicizing a sexual encounter with the president. Okay, so there we go. That's Stormy Daniels. That is Cohen paying her $130,000 to keep her mouth shut, which is odd because she usually makes that money by having her mouth open. In any way, lawyer A made the payment through a shell corporation that he set up and funded at a bank in Manhattan. This payment was illegal, and lawyer A has since pleaded guilty to making an illegal campaign contribution and has served time in prison. Well, let's talk about that. You're saying this payment was illegal, but guess what? It's not illegal to pay whores to keep their mouth shut. It's not illegal to be blackmailed or to pay blackmail to anyone. It's not illegal to enter into an NDA to pay to have someone not say something. Those aren't crimes. That's perfectly legal. What we're getting at here is that Michael Cohen was prosecuted for this payment as an illegal campaign contribution. Actually, he was prosecuted for a whole bunch of stuff. His plea deal, he agreed to plead guilty to making an illegal campaign contribution. So he pled to being guilty based on a plea deal where, he might have spent substantially longer in prison if he had not agreed to that plea deal. Is that evidence that this was that Donald Trump was involved in an illegal scheme? No. I mean, I guess it's evidence. Is it proof? No. We know that Michael Cohen paid her $130,000. He pleaded guilty to it. He pleaded guilty to that payment being an illegal campaign contribution. That's a little tricky here, and I'm not sure how to handle that. Had Donald Trump just paid her the money directly, which, by the way, is what he should have done. Michael Cohen, my opinion, is a shitty lawyer. Don't pay the defendant, or don't pay the whore yourself. Okay, your client has to pay the whore. You don't pay the whore and then come back and ask for reimbursement of your client. He's probably doing that to try to put some distance between Donald Trump and him, hence going through this shell corporation. But he pleaded guilty to making an illegal campaign contribution. But where it says here, this payment was illegal, no, it's actually not. It's perfectly legal. He pled that it was only illegal in the sense that Cohen pled guilty to making an illegal campaign contribution. But you know what? Michael Cohen can give $130,000 to a whore to keep her mouth shut too. So, yeah, it's some evidence that Trump may have been involved in this, but it's not dispositive, especially because it was largely made to prevent a even more stringent prosecution and even more time in prison. So, you know, that's a credibility issue that we'll have to hash out in trial, assume we get to the trial. Okay, false entries were made in New York business records to effectuate this payment. Again, this is all Cohen now. So whatever Cohen did with the entries that he made in this shell corporation, okay, great. Prove that Donald Trump ordered him to make those false records and ordered him to make the payment in this way. I think that's going to be hard to do because the first thing Donald Trump wanted to do is slip Stormy Daniels some cash. He's apparently quite amenable to slipping Stormy Daniels something on occasion. So Donald Trump, hey, you know, well, I'll pay her. All right. So anyway, Cohen makes the $130,000 payment. After the election, Trump reimburses Cohen through a series of monthly checks from the Donald J. Trump Trust. And the checks, of course, were processed by the Trump Organization. Each check, this is important here. Each check was disguised as a payment for legal services rendered in a given month of 2017, pursuant to a retainer agreement. The payment records kept and maintained by the Trump Organization were false New York business records. In truth, there was no retainer agreement, and Lawyer A was not being paid for legal services rendered in 2017. Really? I mean, you might say that there was no formal agreement, but if I say there's a retainer agreement, and I can show that I am, in fact, paying a specific amount of money to a lawyer every single month, I can say I did have a retainer agreement. We did it on a handshake, and I was paying him $20,000 a month every month. Prove otherwise. The fact that I am paying a lawyer a retainer services agreement, and I'm recording it that way, and I'm paying him the same amount every month, that makes it look like I do have a retainer services agreement, because that agreement, maybe it's not in writing. And by the way, Alvin Bragg better hope that there is no written agreement, because that's the only hook that he has here. But the fact is, he just says flat out, in truth, there was no retainer agreement. Really? Well, I got records that say I paid the guy every month for legal services, and you're saying it was for something else. Okay, maybe Cohen will testify otherwise, that this was not a retainer agreement, and maybe he'll testify that, you know, Donald Trump, I don't know what he will testify to, but I do know that from a defense point of view, I would say, hey, the very fact that we were paying him, you know, $20,000 a month or whatever it was on a monthly basis every month, that does indicate that we were paying a retainer agreement. All right, so there's some background. Who's Donald Trump? He was running for president. He became president in January 17th. So now the scheme, the catch and kill scheme to suppress negative information. So, by the way, during and in furtherance of his candidacy for president, the defendant and others agreed to identify and suppress negative stories about him. By the way, isn't that what presidential candidates do? all presidential candidates try to identify and suppress negative stories about them. This is a common thing in campaigning and always has been. Okay, I believe that one of the phrases that was used in here, he tried to influence the outcome of the election. Yeah, he was a presidential candidate. That's literally their job, to influence the outcome of a presidential election. So, the defendant and others agreed to identify and suppress negative stories about him. Okay, not a crime. Now, two parties in this agreement have admitted to committing illegal conduct in connection with the scheme. Okay, did Donald Trump order them to do this? Can you prove Donald Trump ordered them to do this, or were they acting independently? And by the way, the two parties, one is Cohen, and the other is American Media Incorporated, who were not prosecuted for a crime, although in a non-prosecution agreement, they did admit that they paid a source to a story to ensure the source did not publish damaging allegations about the defendant before the 2000 presidential election. Okay, great. So, in 2015, Donald Trump says, I'm running for president. Soon after that, Cohen and AMI, the parent company of the National Enquirer, all got together at Trump Tower. AMI CEO says, Don, I'm happy to help you with your campaign. I'll act as the eyes and ears for the campaign by looking out for negative stories about you. And I'll let Mike Cohen here know if these negative stories exist. Okay, great. Not illegal. But, Donald Trump is not ordering this. They're just all agreeing, hey, that would be great. If you did this for me, that would be great. Donald Trump is not ordering him to do it. There's no indication of that here. This is something the AMI CEO just wanted to do. And by the way, under Citizens United, he probably can. The only thing is he can't do specific things under Donald Trump's direction. So, okay. So, suppressing the doorman story. So there was a doorman trying to sell information about a Trump bastard child, allegedly, and AMI negotiated and paid this doorman. So he's a doorman in New York who said, hey, Donald Trump has an illegitimate child. I would like to sell this story. AMA paid him $30,000 to acquire exclusively rights to this story, or to acquire exclusive rights. Okay. Now, it says they falsely characterized this payment in their books because AMI purchased the information without fully investigating his claims. Okay. Did they falsely characterize this payment? They did, in fact, pay him for exclusive rights. And here's the problem. It doesn't detail how they falsely characterized this payment, or whether they're just saying it was falsely characterized because AMI had a non-prosecution agreement. Where was it? Here, back up here. They had a non-prosecution agreement that they signed with the feds. There we go. That they made a payment to a source of a story to ensure he did not publicize the allegations. So they weren't prosecuted for it. It was a non-prosecution agreement. So you say, basically, if you don't prosecute us for a crime, we'll tell you what we did. And so Alvin Bragg is using this as saying that this payment was illegal. Okay, it was, they did admit to doing it. It did happen, but they also weren't prosecuted for it. Does that mean it wasn't illegal? No, it doesn't. It may very well have been illegal. They may have mischaracterized it. I don't know, but unfortunately those details are not coming out here. All right, so we have that. When AMI later concluded the story was not true, AMI wanted to release the doorman. However, Lawyer A instructed the AMI CEO not to release the doorman until after the presidential elections. AMI CEO complied with that instruction because of his agreement with the defendant and Lawyer A. Where was defendant here? AMI said, hey, the story's not true. This guy's got a bunch of BS. Donald Trump did not have a bastard child. we'd like to release him from the agreement. And Michael Cohen said, no, just hold it till after the election. And AMI said, okay, well, we'll hold that contract, again, exclusive rights contract, until after the election. Okay, well, there's Lawyer A, Michael Cohen. There's AMI CEO, second guy. Where's defendant here? No, they said they didn't do it because of his agreement with the defendant and the lawyer. Okay, so they agreed a year earlier in 2015, or I guess it went to October of 2015. So August, October, November, so 4 months. They'd said, we'll help you out with your election, but they had an agreement that they would help him out. Not sure that that's illegal yet. And then they're saying because of this agreement, but this looks like, from this statement of fact, that's these two guys doing stuff. That doesn't necessarily mean that Donald Trump did anything. This is an assertion that it was the defendant and Lawyer A who is running this. As far as we can see here, this is Lawyer A and the AMI CEO. Donald Trump is not involved here, as far as I can tell, based on the text here. We just have this assertion that Donald Trump was running this. Okay, interesting assertion, but we're not showing me any proof or evidence here that that was what was going on. Then there was Woman One. This is the former Playboy person. She said she had a sexual relationship. Oh, wait, is this Woman One or... yeah, this is Woman One. Woman One, not Stormy Daniels. Woman One is the former Playboy playmate who said that she had a sexual relationship with Donald Trump. Once again, they apparently talked by message or telephone. The defendant did not want this information to become public because of the effect it would have on his candidacy. Well, I'm sure he didn't. And maybe he did mention it in a telephone call. Thereafter, the defendant, AMI CEO, and Lawyer A had a series of discussions about who should pay off Woman One to secure her silence. Okay, interesting. Not a crime still. Not a crime to pay whores to keep their mouths shut. The crimes might come afterwards, but that's not a crime right there. AMI ultimately paid $150,000 to the one. $150,000 to Woman One in exchange for her agreement not to speak out about it. And they gave her 2 magazine cover features and a series of articles that would be published under her byline. AMI falsely mischaracterized this payment in AMI's books and including its general ledger. Okay, let's stop. So Alvin Bragg said, this is money for a payment to keep her mouth shut and not talk about Donald Trump. That's what the $150,000 was for. Except that they did 2 magazine cover features on her and a series of articles to be published under her byline. That sounds like payment for services to me. Now, you're saying they mischaracterized it, or Bragg is saying they mischaracterized it, but I'm not sure because that sounds like a pay for service. If they are doing magazine cover features of her and letting her write in, National Enquirer under her own byline, okay, maybe there's a payment to keep her mouth shut. Maybe it's just an agreement for services. However, there was supposed to be some verbal agreement that the defendant or the Trump organization would reimburse AMI. And their defendant and Lawyer A discussing how to obtain the rights to Woman One's account from AMI and how to reimburse AMI for its payment. Okay. Donald Trump says he spoke to the CFO for the Trump organization about how to set this up and how they were going to pay this $150. And then, okay, now again, by the way, who's paying for this? We're talking about this as if it were a crime here, and Donald Trump is having these discussions now about how to make the whore mouth-shutting payment and who's going to pay it and all of that other stuff. Okay, great. Still not a crime. Donald Trump can pay money. He's not paying it out of the Trump campaign. He's paying it out of the Donald J, of his own money. So again, this is not a crime. What we're doing here is now we're reaching and saying, essentially, all of this is an illegal campaign contribution scheme, and that we're covering it up, this illegal scheme, in order to make an illegal campaign contribution. Okay, that's fine. If you want to make that argument, there are some problems with that argument. One of which is Citizens United. The other of which is it's Donald J. Trump's. If it's his own money, he can make these payments anyway. He can reimburse other people who make payments as well out of his own money. This is not coming out of campaign. This gets us into a very murky area of law. Actually, it's even murkier than we think, but we'll have to look at that here in a little bit. So anyway, they're making all of this agreement. Lawyer A called Resolution Consultants. By the way, this is the part I like. Donald Trump says, how are we going to set up this whole thing? What do we got to pay for this? $150? I'll just pay him in cash. When Lawyer A disagreed, the defendant then mentioned payment by check. Pro tip, if you say to your lawyer, hey, I got to pay money to a whore to keep her mouth shut. Let me slip you $150,000 in cash. And your lawyer says, no, paying in cash isn't a good idea. What if I pay in check? And your lawyer says, hey, paying whores money in checks is a great idea. Fire that lawyer. That's a bad lawyer. Never, if we learned nothing from, who's the Jerry, the guy that had the crazy TV show. I keep wanting to say Jerry Seinfeld. It's not him. Oh, the guy that had the daytime talk show. He was mayor of Cleveland. Jerry, I can't remember his name. Somebody in chat, tell me. In any event, he used to be mayor of Cleveland, I believe. And he was tossed out of office. He had to resign from office because it came out that he was paying prostitutes with checks. Never pay whores with checks. Always pay by cash. So I would have got rid of Michael Cohen right then. If you're telling me I got to pay whores with checks, I don't think I want you as a lawyer. So Cohen goes through this whole thing of creating a shell company and then running the checks through the shell company. Okay, again, fine. It's Donald Trump's money. Is it blackmail money? Maybe. I'd certainly make that argument. I was being blackmailed and I paid blackmail money. Paying blackmail money, not a crime either, any more than paying an NDA is. And so anyway, the AMI CEO signed an agreement to transfer the right to Woman's One account to Lawyer A's shell company for $120,000. Then AMI CEO talked with the general counsel, and then the general counsel said, no, we can't do that. We'll scotch that deal. So the transfer apparently of the $125,000 actually never took place. Jerry Springer, that's it. The 56th mayor of Cincinnati from 77 to 78. Yes, whenever he was unfortunately caught. Okay, suppressing Woman's 2's account. And this gets us into the Access Hollywood tape. You can grab them by the pussy. You can do anything. All of that. Okay, interesting. So he said that to the Access Hollywood host. Who cares? Not a crime. Don't care. Shortly after the Access Hollywood tape became public, AMI found out about Stormy Daniels, and AMI notified Michael Cohen. Cohen got connected with Lawyer B. Michael Avenatti, who is now residing in prison. Good job, Michael. From potential president to jailbird. So they made a deal to pay Stormy Daniels $130,000. But Donald Trump now said, hold on. Let's see if we can hold this off till after the election. Because if we can hold it off till after the election, it won't matter. She can say anything she wants because I've won. So at this point, Trump is saying now, don't pay her. See if we can delay this at least till after the election. Then we won't pay her at all. However, with the election approaching, pressure mounting, the defendant agreed to the payoff and directed lawyer A to proceed. So who's pressuring who here to make the payment? Because apparently Trump didn't want to make the payment, but ultimately did. So made the $130,000 payment, and everybody agreed. Lawyer A, Michael Cohen, shortly on or about October 26th of that year, set up Essential Consultants LLC, and he created this as a shell company to make that payment. He transferred $131,000 from his personal home equity line of credit, and then wired that $130,000 from Essential Consultants LLC to lawyer B, who I believe in this case is Michael Avenatti. Okay, after the election, on November 8th, AMI released both the doorman and woman one from their non-disclosure agreements. Donald Trump got inaugurated. They met with him privately in Trump Tower. He thanked them for handling those stories for him and actually had him to a White House dinner. Okay, great. Then we come to the actual falsification of the business records. And don't worry, we are almost done. I don't even know what time it is. It's 6 o'clock. So we've been going for an hour here. Well, it's longer than I thought we would actually go. So after being elected president, Donald Trump decides to reimburse Michael Cohen for the $130,000 payoff to Stormy Daniels. Okay, interesting. Doesn't happen until after the election. So I'm a little confused about the actual fact pattern here. And I think that this is probably going to have to be investigated, certainly in Trump's defense. Michael Cohen paid this money all by himself. Now, Alvin Bragg says it was at Trump's direction. I don't know that it was. And by the way, under Citizens United, if it wasn't, Alvin Bragg could have legally made that payment. Now Donald Trump is reimbursing Michael Cohen for the money. So he asks, so the Trump Organization guy says, okay, well, bring me a copy of the bank statement. So the CFO of Trump Organization and Michael Cohen agreed to a total repayment of $420,000. So $130,000 payment, a $50,000 payment for another legal expense for a total of $180,000. They doubled that to $360,000 so that $360,000 would be characterized as payment on Michael Cohen's tax returns instead of a reimbursement. And that would leave him with $180,000 after paying approximately 50% in income taxes. And finally, an additional $60,000 as a supplemental year-end bonus. That comes up to our $420,000. So, again, who's getting defrauded here? The state of New York and the government of the United States of America is now making $180,000 in tax payments that they would not have otherwise made because of the way that this repayment was structured. So, again, who's getting defrauded? We'll come back to that. So then we go through the point here where each month This is where they say that they agreed the lawyer would be paid the $420,000 through 12 monthly payments of $35,000 over the course of 2017. And each month the lawyer was to send an invoice to the defendant through the Trump organization. Again, it says falsely requesting a payment pursuant to a retainer agreement. Again, at no point did lawyer A have a retainer agreement with the defendant or the Trump organization. Again, you can assert that, but you're going to have to prove that a retainer agreement didn't exist. It's best to have a retainer agreement in writing, not necessary. So, and besides, even if all of this is true, we still don't have a crime. We have a lot of facts here about people who are doing this and that, but we don't have a crime there. And then this is all just more about the remittance to Michael Cohen, the $30,000. And again, there is no payment and no services. And the lawyer A was not being paid for services rendered. Okay. Maybe that's true. Still not a crime. Or it is a crime, but it's a misdemeanor whose statute of limitations are up. Because it happened in 2017, it is now 2023. Okay, great, but it doesn't get us to a felony charge. It gets us past the statute of limitations here. Because again, we're trying to look for the crime that is being covered up here. Obviously, they didn't want to say that, they didn't want to publicly say and make public business records that, hey, these are whore payments. So clearly, assuming that the Trump organization's management of the Donald J. Trump Revocable Trust is a business record of the Trump organization, not just that they're the accountants and record keepers for Donald Trump's personal trust, which I think is an issue that needs to be explored. Okay, so they should have put whore money as the general ledger entries. They didn't. It actually would have been best for Trump. You know, people do stupid stuff. If you want to shut a whore up, pay her the money directly. Give it to her in cash. Make her sign an agreement, a non-disclosure agreement, and shut her up. This going through intermediaries and stuff, even if legal, even if, these people were doing this because they wanted to support Donald Trump and Donald Trump was not directing them. And by the way, the fact that they had agreements about, hey, it'd be great if you guys did this, if you look out for me, help me out, blah, blah, blah. That doesn't necessarily mean Donald Trump directed any of these acts. It's overly complicated to do that. Maybe the agreement you have is tell me and I'll pay them out of my personal fortune so that they will keep their mouths shut and will keep it under the rug. You don't need to get involved. Michael Cohen doesn't need to get involved, except other than as my go-between. And whatever you do, Michael, don't pay these people off. It'll have to come out of my money. Oh, and by the way, we're doing it with cash. So this is complicated. And now we get into, this was described as a legal expense, all of these payments to Cohen. It goes on for pages and pages and pages about that. This is all retainer payments, blah, 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 blah. The $35,000 payment stopped after the December 17 payment. Okay, let's assume it's all true. What we're hiding is whore money. Alvin Bragg says we're hiding some other crime. It'd be great if we identified that other crime, wouldn't it? But we're not. We've got a whole bunch of sketchy behavior here. It's Donald Trump. Are you surprised that Donald Trump is engaged in sketchy behavior? And people around Donald Trump are engaged in sketchy behavior. But even if we agree, arguendo, and by the way, it's not even arguendo, I think it's quite obvious that if these are actual business records, they were falsified. It is business records falsification in the second degree. Again, it's a misdemeanor. Nobody's going to go to jail for it. You're probably going to get fined, the organization, and it has a 2-year statute of limitations. So Okay, I'm not even arguing that the 175.05 of the New York Election Code, I'm not even arguing that that didn't occur. So I'm pretty sure that 175.05 actually happened. And it is a Class A misdemeanor. So they were very naughty boys. But again, our problem is we're falsifying business record, or our intent to defraud includes an intent to commit another crime. So we actually have two problems here. The fact that a business record is false is not necessarily a crime. It's a crime if it's false with intent to defraud. Now, we've talked about a lot of sketchy behavior here. We've looked at a lot of sketchy behavior here. And I'm even willing to admit arguendo that 175.05 was violated. Arguendo, except with intent to defraud. Who was defrauded? I mean, the government wasn't defrauded in the sense that when they say it was mischaracterized for tax purposes, yeah, so that we could pay the government more money than we needed to. So they're not being defrauded. The only person who's actually paying anything out for this is galactically dumb Donald Trump, who, because he used a go-between to pay Stormy Daniels $130,000, he ended up having to reimburse him for $450,000, $500,000, when he could have just paid Stormy Daniels $130,000. There's no reason to complicate this stuff. Look, just, pay your whores directly. Don't go through go-betweens that are going to make you charge or make you pay 3 times as much to get the same result. That's just, dumb. All right, so from there on in, we go into all of the other things, and we get into the lawyer A, Michael Cohen, and AMI admitting guilt in their payoffs. So AMI entered a non-prosecution agreement with the U.S. Attorney's Office for the Southern District of New York, admitting that did AMI intend to publish the story or disseminate information about it publicly. Rather, they did it to the woman, did not publicize damaging information about them. You know what they didn't plead guilty of? To Donald Trump, and they didn't even plead guilty, by the way, but they didn't say Donald Trump made them do this. And by the way, when you have an agreement with somebody, this is woman one, this is the Playboy model, who was going to get her, byline and cover stories and all that other stuff. They said AMI did not intend to publish that story, even though they bought it. Okay, is that a crime? Maybe. I mean, it may be a violation of election law, but it may not be. Now, they went through a prosecution agreement that was, if I agree that I did a bad thing, you won't prosecute me. So I won't have to worry about showing up in a federal court. I won't have to worry about possible criminal charges. Won't have to worry about sanctions. Won't have to worry about civil sanctions against my business. All I have to do is sign a piece of paper that says I was a bad boy and I did naughty things, and then you go away and stop bothering me. So, okay, great, but and maybe everything that they said is true, and they said it was a crime, or they at least admitted that, we made and by the way, this is an illegal campaign contribution. That's what they're admitting to making. Again, Citizens United, I don't think that this is an illegal campaign contribution. You can make independent expenditures in whatever amount that you want to support a candidate. You just can't do it at that candidate's direction. But if it's independent money and you're doing it on your own dime, I'm not sure that's a crime. On the other hand, do I want to go through a year and a half of federal prosecution just to come out and probably be found guilty, because it's the Southern District of New York, so probably be found guilty and then have to go to the whatever circuit it is. That's New York and New Jersey. I don't remember. Is it the Fourth Circuit, Fifth Circuit? Don't remember. Now you have to go through the appeals court, and ultimately there's a good chance that somebody will say, hey, Citizens United covers this, and they will overturn your conviction. But of course, now we're 4 years down the road and millions of dollars in legal fees later. So if the AUSA for the Southern District of New York says, hey, sign this and I'll just go away and never bother you again, do you spend the millions of dollars and possible conviction and then appeals and then years before hopefully being exonerated because of Citizens United? Or do you sign the piece of paper and you never talk to the AUSA again? I think you sign the piece of paper and you never talk to the AUSA again. So yeah, you might have admitted all sorts of stuff because you're negotiating a non-prosecution agreement. Okay, you know what? If you tell me, if I sign this, you're going to go away and I'll never see you again. But if I don't sign it, I might go to federal prison, or I'm at least going to be in a federal court for a year and a half or 2 years. You know what? I think I might sign it. So, so Allenbrecht says, okay, this is a crime. Is it? Maybe. I mean, no one was charged with a crime. And by the way, you don't have to be charged with a crime to allege that you were covering up a crime. There doesn't have to be another crime that was actually charged. You could have just had a conspiracy to cover up the other crime. Interestingly, Donald Trump not charged with conspiracy to commit a crime. It's just an assertion that it was done with the intent of committing or to cover up another crime, a crime that is currently unspecified. So anyway, this is all about their non-prosecution agreement and what they said. And then you have Cohen pleading guilty to a felony. And so he says, at the direction of a candidate for federal office, I am the CEO of a media company, work to keep individual information out of the public limelight. Okay, great. You're saying that this is part of your guilty plea. That is the plea bargain that you made. Maybe it's true. Maybe it's not. You're going to have to come and be cross-examined about that in a criminal trial, Mr. Cohen, because you admitted that you did it, but was it an actual crime? Well, we don't know because you just admitted guilt. And then there we go. That is the end of the statement of facts. So, 2 takeaways that I come from this. A, Donald Trump is a shady fuck. Okay, agreed. He is. Don't have a problem admitting it. So, fine. We know that that's true. Our problem is twofold. A, I've got to make these these false entries with an intent to defraud. I can't find anybody who was defrauded, and it was to commit another crime. We don't know what the other crime is. What we did say in the statement of facts, and it was one sentence here, maybe in the indictment. So let me go back and check the indictment because I really wanted to discuss that because that has been bothering me. So I get to commit another crime and conceal the commission of another crime. So maybe it is back here in the statement of facts. And it's this one real, it's one little phrase that jumped out at me when I saw it. And let's see if I can go ahead and find it. Election. Here we go. Yeah, it was right here, right at the beginning. In order to execute the unlawful scheme, the participants violated election laws. Okay, that may be true, but here is the problem. Even if they did violate election laws, DAs don't enforce election laws. And in New York, I know, because nobody else has it either, there is no way that a DA uses an election law, a federal election law, as the basis for a state prosecution. In fact, there is a Supreme Court case from back in the 90s. I think it was about 1997 or so. Prince, I believe it is, Printz, which basically says this is a separation of powers issue. Local DAs do not enforce federal laws. They don't charge federal laws. You have to be able to charge a federal law. So if, and again, we don't know, because we don't know what the crime was that the defendants, or Donald Trump, the defendant, intended to commit or to cover up, or did commit and cover up, or aid in the commission of. Because that crime is not specified, we don't know what they're talking about. If it is federal election law, then what he is saying is that I can charge you on a state crime based on an intent to commit a federal election law violation. That's not what the law is currently. And even though in New York, the statute, and Alvin Bragg brought this up this past week, if we go back and look at 175.10 and 175.05, it just basically says, 175.10, that your intent is to commit another crime or aid and conceal the commission thereof. The statute does not, in fact, specify what the other crime might be. If you're going to do this based on a federal crime and you're going to make a state charge out of it, I think that's probably going to head to the New York Supreme Court. Because there is no law outside of the federal law that Prinz says local DAs don't enforce federal law because of separation of powers. This is a separation of powers issue. It's a federalism issue, actually, where states are intruding on an area where the feds have basically primacy. So I don't know if you can actually use that to support a 175.10 charge, because you're trying to say, well, he was trying to commit a federal crime, and the statute doesn't ban me from using federal crimes. Well, the statute probably doesn't ban you from a lot of stuff because it doesn't expect you to do so. So that's going to go straight to the Supreme Court if we're using federal election law. However, we may not be. Remember how I said at the beginning, your intent to commit a crime doesn't mean you actually had to commit a crime. You could have just been planning to commit a crime, in which case I would have expected Trump to be charged with conspiracy. He wasn't. And the crime is not specified. So there are a lot of big holes in these charges. But New York's election law, section 17-152, it's only a misdemeanor, but it says conspiracy to promote or prevent an election. Any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of a misdemeanor. So this is a conspiracy charge. It is a misdemeanor conspiracy charge to promote or prevent the election of another person. So New York State does in fact have a law that says it is a misdemeanor to promote or prevent the election of any person by unlawful means. So technically, let's leave the federalism part out of this. Technically, Bragg could argue that what the charge is, we've got a 175.10 charge based on this crime was committed, these falsified business records. We still haven't figured out who was defrauded. There's no mention anywhere in any of these documents. It says there was an intent to defraud, but there's no explanation here or in the statement of facts of who was defrauded. But let's leave that aside for now. That's a hole, but let's leave it aside for now. If you want to close up the 175.10 conviction or charge, New York actually has something on the books that would allow it. If I was prosecuting it, and by the way, if I was a cop, if I was writing this up, that's how I would write it. I would not write a state law into a federal charge, and I would not write a federal charge into a state, or a federal law into a state charge. I've already got a state law that I can use. Even though it's guilty of a misdemeanor, if I can show that you conspired to use unlawful means to promote a candidate, which that's a door you can big enough to drive a truck through. There may be some specificity issues with this in terms of civil rights and First Amendment. I'm sure it's probably never been challenged, but this seems like a pretty vague law, but it exists. It's on the books of New York State. If I'm Alvin Bragg, I don't have to go and grab a federal crime that they were attempting to commit. I've got conspiracy to promote or prevent an election. Yeah, it's a misdemeanor, but that doesn't matter because, again, we go back to 175.10, an intent to commit another crime. Doesn't have to be a felony. It can be another misdemeanor. And I have got a state election law that seems to be big enough for me to drive a truck through so that I can make a valid 175.10 charge based on the intent to commit a violation of 17-152 of New York's election law. So there's been a lot of people saying there's just no there. And I think to a certain extent that they're right. Because where there is no there, and I've been talking to you here, instead of screen sharing all of this legislation, here is the section we were looking at that I meant to show you and that I never showed you, your conspiracy to prevent the election. Sorry about that. I was mixed up on whether I was showing my desktop or whether I was showing me. Forgive me. So in any event, we've got this law and all these people who've been saying, well, if he's trying to shoehorn federal election law in, that's not going to fly. Probably won't, because to do so would literally be making new law. But he doesn't have to. He actually has a valid charge here if he can bring in 17-152 on that charge. Then we don't even have to discuss federalism at all. So it's not as much of a reach as you think, with the exception of all of this stuff down here, all of this statement of fact stuff. Who was defrauded? I mean, we have all of this horrible behavior, but what we don't have is anybody being defrauded. The only person that paid for this was Donald Trump. The American taxpayers didn't do it. The taxpayers of the state of New York didn't do it. In fact, they got a windfall out of all of this. They were able to, have their cake and eat it too. And Donald Trump, well, he ended up paying way more in whore money than he should have paid. So there we go. That is my run through of the statement of facts. I'm sure there were some things that I'm wrong about. Again, as I said at the beginning, I'm not a lawyer. If I was writing this up to present to a federal prosecutor or a judge advocate general, I would have certainly, to support a 175.10 charge, I would have specified the following elements. A, that business records were falsified. You know what? It looks like that's a slam dunk. Looks like business records were falsified. However, defalsified. It looks like business records were falsified. However, were they falsified with an intent to defraud? Okay, well, that requires that I find someone who was defrauded or who would have been defrauded if the defendant's scheme had come to fruition. So who is their theory of who is being defrauded? Because that gets me to 175.05, which is the misdemeanor second degree falsification of business records. And then beyond that, then I have to reach that second stretch. I did it to prevent the commission of a crime. Now, that intent is going to be hard to prove here because, A, what is the crime that you're intending to commit? Because Donald Trump, by the way, Donald Trump can spend as much of his own money as he wants on his campaign. If you self-fund your campaign, look, people give you money. There are many, many federal requirements about how you have to handle that money, what you have to do with it, how you have to report it. There are limits into what these other people can give to your campaign. But you can throw as much of your own money as you'd like into your own campaign. There are no campaign finance limits. There are no restrictions on self-funding your own presidential campaign. So Donald Trump could pay money to anybody in order to shut them up. And you can't say boo to him about that. So when you strip all of this away, since all of these checks were paid from the Donald J. Trump Revocable Trust, they were all paid by Donald Trump. And Donald Trump can spend anything he wants on his own election campaign. And Donald Trump ultimately paid for all of these payments to all of these people. Everybody who made a payment initially were all reimbursed by Donald Trump. Sure, Cohen pled guilty to a crime. Yes, AMI agreed to a non-prosecution agreement, which, by the way, you can sign a non-prosecution agreement. Doesn't necessarily mean that you committed a crime. And by the way, if there was a really serious crime there, we have to ask why the AUSA would have not offered them a plea deal that required them to plead guilty of something. But we have no conviction against AMI because they weren't prosecuted. Now, maybe that was done so that they could get to Cohen. Okay, fine. But at the end of the day, Donald Trump ended up paying all of these expenses himself. So what crime was being covered up? Because Donald Trump can't violate election laws by making an illegal campaign contribution to himself. So I don't know how you prove that Donald Trump had this intent to violate federal law when Donald Trump can spend whatever he wants on his own campaign. He can give money to anybody. Hell, he just hired Laura Loomer. I should think that paying that lunatic would be a campaign violation, but nevertheless, he did it, and it's perfectly legal for him to do so. Donald Trump can spend all the money that he cares to, and Donald Trump can pay off any whores that he wants to, and nobody can say boo, because it's not a crime. So I think you would, and there are a couple of things in here where they're having these discussions where I'm not sure that Donald Trump thinks that he is committing a crime. I'm not sure that he thinks he's doing anything but trying to keep people to, shut up and not come out with damaging information during his presidential campaign. He could have done it a lot simpler. He didn't need to involve AMI or anybody else. I mean, all they had to do is just dial him up and say, hey, Don, there's somebody that says something. Send Cohen out, have Cohen go out, talk to the guy, write up an NDA, pay for it, and it's all perfectly legal, and you can spend as much as you want. So, again, I think it's a weak case. The idea that Donald Trump was trying to cover up the commission of a crime, it's not clear at all that Donald Trump was trying to cover up the commission of a crime or the activities in which he was involved in did he even think might be crimes, because, again, he's not covered under election law the way people other than the candidate are covered. And boy, we can talk about how bad election laws are and whether people should be covered under those election laws and whether there should be campaign finance limits. There's a whole bunch of stuff we can talk about there. But I don't believe that time gives us the ability to do that. So rather than looking at you, because I am a one-man show here, I'm trying to find my outgoing music so that we can say goodbye. And I really should have picked that earlier, but I'll just pick the old Stand by American Cars, and that's what we'll go with for our outro music on the day. So that's all I've got for you this afternoon. What time is it? It's 6:34. Hey, I managed to drag this thing out for an hour and a half all by myself. Maybe I'm a little dangerous. Well, I'm dangerous when I have 20 pages to read and access to a microphone. So there you go. Thanks for joining me again this week. Next week, again, Michael not going to be available. I'm going to set up a stream. Not sure what it's going to be or how long it's going to be or even if I'll do it. However, we did do this one. It is in the can. And with that, I will say goodbye. Have a great week. And hopefully we'll be able to talk to you again next week. Until then, so long.